Is your will your attorney's retirement plan? Hi, I'm attorney Karl Shehu, the founder and managing member of Shehu Legal here in Connecticut. And today I'm going to explain how your will-based estate plan is essentially your attorney's retirement plan. Now, to illustrate that, I'm going to explain what I mean by your will being your attorney's retirement plan. I'm going to use an example to show you how that's true. And then I'm going to explain what you can do to remedy that situation. Okay, so when I say your will is your attorney's retirement plan, I don't mean he's actually doing something underhanded. What I mean is that your will guarantees that attorney future business down the road. So today's will client is tomorrow's probate client. Okay, so let's take a look at an example. Here he meets Wanda, they fall in love, they get married. This is the typical American story. They buy a house, they have some children. One day, Wanda's watching the news and she sees a story about a mother of 5 who tragically died in a car accident. Wanda remembers her own car accident a few years back, and she begins to think, well, what if something happened to me now with my own children? I'd want to provide for them. I'd want to provide for my husband. So she has a conversation with Harry, and the next day they phone John. John was the attorney who handled Wanda's personal injury a few years back. And they tell John, well, we just need a simple will. John says, come on in, happy to help you out. They go in the next day, they sit at John's conference table, he drafts the will for them, and they sign it. It costs them $2,000 for this will. And they think, all set. Things are handled. Well, 25 years later, Wanda unfortunately dies. And so here he picks up the phone and he calls John. And John says, well, I'm happy to handle the probate for you. Bring down an $8,000 retainer. So here he's confused because he says, well, I drafted a will and I thought that we would be avoiding probate. And John explains, well, no, a will is actually an election for you to go through the probate system. So here he thinks, well, what am I going to do? He brings down the $8,000. And then 10 years after that, unfortunately, Harry passes away himself. And his heirs, his children, now pick up the phone and call John. John says, happy to handle your father's estate. Bring down $10,000. Because let's face it, things go up. So the children think, well, what are we going to do? They go and they bring 10 grand down to John and he handles the probate proceeding. So that initial $2,000 will didn't cost that family $2,000. It cost them $2,000 up front, and then $8,000 at the first death, $10,000 at the second death. The overall price of that entire estate plan and administration, $20,000. So what is the remedy to this? Well, had Harry and Wanda drafted a trust-based estate plan, yes, it would have cost them more up front. It probably would have cost them about $5,000 for that trust, as opposed to $2,000. But at Wanda's death, Harry would have paid nothing in attorney fees. And the reason for that is because here in Connecticut, you would have to open up a probate proceeding, but it would be mainly informational. You're opening it up. You're letting the probate court know that, Wanda had died and you're paying the probate fee, but that's it. This isn't something that would require you to hire an attorney. And upon the second death, the same thing for the children. They wouldn't need to hire an attorney. They're opening up a probate proceeding to apprise the court that Harry had died. So they would have been in that trust for $5,000 up front, and that's it. Whereas they would have been in that will-based estate plan for $20,000. So the difference between a will-based estate plan and a trust-based estate plan, $15,000. So when you go into your attorney, don't go into him and say, I'm looking for a simple will. Rather go in and say, I need an estate plan. I want the plan that is going to protect my family the most and cost me the least in the long run. So is your will your attorney's retirement plan? Well, if you take a look at the initial estimated cost for a will versus a living trust, you're going to see that a will has the advantage. But after the first death and the second death, you're going to be paying your attorney between $8,000 and $10,000 for each of those deaths and probate proceedings. So the overall costs of a will versus a trust gives the advantage to a trust. If you have a will-based plan, you have guaranteed your attorney future income, and therefore you have become part of his long-term retirement plan. And any attorney who is worth his salt will push you in the direction of a trust, depending on your assets and depending on the size of your family. I hope this helps, and I hope it points you in the right direction. I'm attorney Karl D. Shehu. Memento mori, God bless, see you next time.